Hey y'all, there's a verdict. So let's see. I know it's gonna take people a while to come in if anyone comes in. But I don't know what to talk about. 40 minutes, a verdict. $42. When I was watching the chat in Law and Crime, someone said that the fastest verdict they've ever had was 80 minutes. So I guess now this, if that's true, I guess now this will be let me send a message on Discord real quick. I don't even know what my thumbnail says. I might need to edit it. Oh wait, hold on. Let me change it. I knew it. Shoot, I might have to change it on my let's see. It's verdict. I'm trying to change the thumbnail. Let me see, one moment. I'll leave that play. I'll be right back with you. I'm trying to find change the thumbnail. Okay, what do you think the verdict's gonna be, you guys? I don't know. I need to change the freaking thing. It's not going to change on StreamYard, so I'm gonna have to send it to my laptop. I don't have StreamYard open. Let me see. I can do it now. Yeah, but I need to change the thumbnail. Hey Cheryl, how are you? Yes, we know that she's guilty, but do you think that they're gonna go ahead and do the by reason of insanity though? Man, everybody's there waiting for the judge. You tell the judge to hold on, Sherry. All right, let me see. I need to. Hey. Um. Yeah, she pled not guilty by reason. I don't know how you do not guilty by reason of insanity, because if you're not guilty, then there is no insanity because you didn't freaking do it. I don't know. I'm changing my thumbnail right now.
My understanding is the jury has a verdict. Is that correct?
Yes.
There we
Anything
go.
to bring the jury in? Mr. Saunders?
No.
Mr. Fraley?
No.
Very good. Then we'll bring the jury.
And it still says tomorrow, 8:30. Good Lord Almighty Jesus. All right. Got it now. Well, first we got to find not guilty or guilty, and then, um, sorry, I was gonna say something. If found not guilty, then of course it's over. If found guilty, then they have to decide if it
Ma'am, are you the foreperson?
insanity or
And
not.
my understanding is that the jury has reached a verdict. Is that correct? Right. If you would hand that to the bailiff then, please.
Hit that like button for me while we're waiting for the verdict.
Okay. First verdict reads as follows. We, the jury, find the defendant, Taylor Denise Shabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this date, July 26th, 2023, signed by the foreperson. Second verdict reads as follows. We, the jury, find the defendant, Taylor Denise Shabusiness, guilty of mutilating a corpse as charged in count 2 of the information, dated this date, July 26th, 2023, signed by the foreperson. The next verdict reads, we, the jury, find the defendant, Taylor Denise Shabusiness, guilty of third-degree sexual assault as charged in count 3 of the information, dated this date, 26th day of July, 2023, signed by the foreperson. The verdicts appear to be in order. Either the parties request that I poll the jury. Mr. Saunders?
No.
Mr. Fralick?
Yes.
Okay. Ladies and gentlemen, I'm going to do what's called polling the jury. It's a very simple process. All I'm going to do is go down the line and ask each of you if this is your verdict. Your answer is either yes or no. I'm going to start in the back corner, ma'am. Are these your verdicts?
Yes.
Ma'am, 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 are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
In the front to the right, ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts? Okay, the jury has now been polled. Ladies and gentlemen of the jury, for today, your tasks are concluded. We're going to start tomorrow morning on the second phase, at which point in the beginning I will give you some further instructions, and then we will get underway on that phase. The attorneys and I have a few things that we're going to need to take up before that phase starts. So I'm going to ask that you be in the jury room by 9:15. I want to start right at 9:15, and we will hopefully get our matters resolved ahead of that time. But for today, your service is concluded. I am going to, again, read you that instruction that I've done every day since you've started. Please do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. We are done for today. Have a good evening. We will see you tomorrow morning at 8:50 or 9:15 sharp. I'll rise for the jury.
You guys, please hit that thumbs up for me. There's only 4 thumbs up.
Be seated. Is the matter regarding Dr. O'Donnell still a contested issue? I'm seeing nods from the state.
As of last night, yes.
So here's how we're going to handle this. I've indicated to the jury that I want them to report at 9:15. Mr. Freilich, it's entirely up to you if you want to bring Dr. O'Donnell here tomorrow morning at 8:15 for me to hear from. But I'm going to indicate to you the parameters of where that situation is. I've reviewed your memorandum, which is all I can really work with because this is what you've essentially said to me. This is what he's going to testify about. The first opinion is that Ms. Shabusiness was acutely intoxicated and impaired by acute methamphetamine use at the time of the alleged asphyxiation. The problem I'm having with that assertion is I'm not sure it's relevant given the status of the intoxication defense. So I'm not sure that having it here is going to assist you in that, but and I need you to understand where I am regarding that topic before you decide that's what you want to bring it here for. The next point is that the long-term and excessive use of methamphetamine has chronic brain damage consequences. The problem with that situation is I don't know that he is competent to diagnose chronic brain damage. So while he could assert that long-term excessive use of methamphetamine has chronic brain damage consequences, I don't think he's going to be qualified to testify that as a professional, I can say to a reasonable degree of certainty used in my profession that Ms. Shabusiness has chronic brain damage. Frankly, I think the only opinion that's been asserted regarding her mental health condition as far as a diagnosis is bipolar, and that was done at Nicolay, and there's some dispute about whether that was an accurate diagnosis, but I don't know that one would qualify bipolar as being a chronic brain damage. So I'm concerned that if he's going to come in and start opining about that the connection won't be made. And then, of course, even if he is able to say that she does have chronic brain damage, the next step he has to take is that somehow that impacted responsibility. And I think there's a concern there as well. But I'm putting you on notice of that view that I'm starting to develop regarding the submissions you've made to me. The second bullet point is that long-term adolescent use of marijuana arrests brain development. Again, I'm not familiar with the diagnosis that any qualified psychologist or other professional qualified to make such a diagnosis has actually made in this case. I don't know that one equates brain development with bipolar. I've never heard that, but I'm not an expert. So the notion that you can opine that someone who uses marijuana as an adolescent might have brain damage, I'm not sure is going to be useful to this jury because we don't know if your client has that. And the next step is, how does that affect responsibility? And I'm not sure he's qualified to give that opinion either. The next bullet point is Ms. Shabusiness was not treated with psychotropic drugs to control or mitigate her psychiatric illnesses. He certainly, and again, I want to say, I'm satisfied that he's qualified as a pharmacologist. I'm not questioning his qualifications as that. Certainly, I reviewed his CV and listened to his testimony at the prior hearing, and he's a qualified pharmacologist for sure. But as far as psychiatric illnesses, again, the only thing that I've heard about from the testimony in the records is a bipolar diagnosis at Nicolay, which these other psychologists have repeated. So that the only thing that one could conclude from this assertion is that she was not treated with psychotropic drugs to control or mitigate her bipolar disorder. And then the question is, how does that impact responsibility? Many people have bipolar, so the next question you have is does someone who has bipolar, will the consequences be that you're unable to appreciate the responsibility in a criminal case? That's another concern I have with whether he's going to be qualified to even testify about that. The next point is psychotropic drugs do have efficacy in a large percentage of patients who take them. I'm satisfied he'd be competent to testify about that. I'm not sure how that actually, first of all, how that relates to whether or not, what she has been diagnosed with, how that would affect an individual by taking psychotropic drugs, and can he say how it would have affected somebody to a reasonable degree of certainty used in his profession regarding the impact of untreated bipolar disorder. That certainly might be within the ken of your other expert, and I do want to indicate you have another expert who might be qualified to testify about some of these things, but I'm very skeptical that this witness is qualified to do so. And then the final point is that Ms. Shabusiness' use of methamphetamine worsened her untreated psychiatric condition. So really, the issue is the impact of methamphetamine on untreated bipolar and the impact of methamphetamine untreated bipolar on someone's responsibility to commit a crime. And I'm just concerned there as well that there's an inability to connect all of those dots with this expert. And so while I'm willing to hear from your expert, because you've asked that, and I think the state is of the mind, we don't even need a hearing on a Dauber hearing on this, but I'm affording the defense an opportunity at 8:15 tomorrow morning. If you want to bring Dr. O'Donnell in to opine on some of this, but you need to understand that's the concern I have. It'll be a rather short Dauber hearing for this reason. This proceeding tomorrow is the nature of a civil proceeding, and I'm pretty certain the judge is not even mandated to hear testimony in a Dauber hearing. I can do a paper review and make a determination, and so I can tell you that I've done that paper review so far, and those are the concerns that I have. And I'll want to drive directly at those issues tomorrow. I'm not going to want to hear about a lot of things that if I can testify, I might be able to say a whole lot of things. I'm going to want to know specifically about my concerns, and if they can't be directly addressed, then I would be satisfied that he's not competent to give those opinions. Even though, again, I want to indicate out of respect for Dr. O'Donnell, I'm satisfied that he's a very capable and competent pharmacologist, but I'm concerned about some of these opinions, particularly when the psychologists who would be rendering the diagnoses that he is referring to aren't even in agreement on it. Nonetheless, that's where we're at. Let me just turn to the state. Mr. Saunders, questions on what I've indicated?
No, I don't.
Mr. Frail, questions on what I've indicated?
No, Your Honor, it's very clear.
All right, very good. We'll see everyone then tomorrow morning at 8:15.
All right, thank you. Stand up. It's okay. Chance, when you're ready. Chris, you good?
Okay, so tomorrow morning, they are going to start phase 2, which is to decide the insanity part. Yes, he said, are they trying to say that if you are bipolar, you have chronic brain injury? That is like the craziest thing I've ever heard besides what this girl did. So they found her guilty on all three counts. Tomorrow morning we'll start again. They're starting an hour later. I think they said to be for them to be there 9:15, 9:30. So yeah, I'm still not getting up at 7. I need that extra hour. So I will be, y'all hear Penelope? Um, y'all hear her? She wants to get up in the bed. All right, you guys, I will be back tomorrow morning with phase 2 of this crazy trial, and it will be over tomorrow. Thank goodness gracious. I will see you guys tomorrow. Thanks for watching. Please hit that thumbs up for me, guys. It's free, easy to do, and I don't know why you don't want to do it.